Hi, I'm Brad Hunter, family law lawyer and family law mediator. I want to talk to you today about the 25 reasons that you don't want to go to court. So I'm going to give you 25 reasons. And how did I come up with 25? Well, that just so happens to be the number of documents that you need to file to get a simple court order. That helps explain why the court system is complex and confusing. When you hear people say it's expensive, now you know why it's so slow. It's all paper-based. There's no electronic filing in Saskatchewan on these matters. And mediating a settlement will avoid all of this hassle for you. So I'm just going to talk about a typical case, a couple with a couple of kids, a house, and they want to get a temporary court order to set support, to set a parenting order. So I don't want to go to mediation. I want to do that. How easy is it? So I bolded those things that take a lot of work. And the first thing you have to do is get your case started. So that's the commencement documents. There's something called a petition, a property statement, and a financial statement, where you have to attach 9 different documents. All of them require quite a bit of work. And there's a number of other documents you need to file. And by the way, before you'll be allowed to go in front of a judge, you will have had to go through family dispute resolution, which means mediation in most cases. So you may want to start there, or you'll need to get a waiver, which is pretty hard to do. So once you've started, the next step is the judicial case conference. So this is a meeting with a judge that allows the judge to tell you what you need to do and how you should go forward on your case. You have to file quite a few documents on this process. I've counted 9 documents to go from beginning to end, and you have to go to court at least once personally, or your lawyer has to go on your behalf. So after the first 17 documents, you can finally start the process of going to court. So then you can bring your court application. Now, this is a bare minimum number of documents you'll need to file. You need to file a notice of application, which details what you want, a detailed court order. It may have changed from the one we talked about before, showing a judge what you want. An affidavit. Now, often you'll file more than one affidavit, and these can be very lengthy and can include a lot of exhibits. And then you can go through the whole process. And once the judge makes a decision, you or your lawyer has to prepare the order of what the judge actually decided and issue it yourself. Now, let's talk about what your ex needs to do. Well, if they're going to reply, again, this is a minimum. They will need to file an answer, which is a formal reply to your petition, or a counter petition if they want something themselves, their own property statement, their own financial statement with 9 documents attached, and a number of other documents, including their affidavit, and they may file more than one. There's a lot of other documents that may need to be filed, from additional affidavits. You probably want to file a reply to your spouse's affidavit if you started it. Normally, you'll have a brief of law. Your ex will have one too. And there's many other documents. So I get a count of 44. If you had proof of service, you're well over 50. So it's easy to understand why this is expensive and why it's time consuming and why it's confusing. And finally, everything must be filed at the courthouse, all on paper. That requires, by my count anyway, at least 8 trips just to file documents to the courthouse by you or your lawyer or staff. Why the process takes so long, it can take months, and why it's expensive. And either you or your lawyer actually has to appear in court a minimum of 2 occasions. So what conclusions can we draw from all this? The law requires you to attend family dispute resolution. So why not start there? That's something I can help you with. I do mediation, arbitration, and I'm a collaborative lawyer. So get in touch if you want to meet and discuss what your options are. So with all this said, I wish you good luck, and it's a complicated process. And if there's any way I can help you get through this difficult time in your life, please feel